Namaste, Sakshi, Manasakshi. I am Priya Goteti. Welcome to Immigration Talk Show with attorney Ms. Prashanthi Reddy from Law Offices of Prashanthi Reddy, PLLC. Please note that now Sakshi TV has 5 immigration shows every week: Monday with Somirari Law Firms, Tuesday with Kaveti Law Firms, Wednesday with Prashanthi Reddy, Thursday with Naresh Gehigaru, and Friday with Banu Ilender. Please tune in to ask your questions, and if you are an immigration attorney and would like to join our special shows, please call us at usa@sakshi.com or 866-725-7449. Before any further delay, let's start our show. But before that, I would like to give a disclaimer that Sakshi TV or its agents are not responsible for use of this information. The information provided on the show is only for general purpose only. For any specific legal advice, please contact the attorney directly. Hi, Prashanthi Garu. Welcome to our show.
Hello, how are you?
I'm good. How are you?
Great.
Prashanthi Garu, today our topic is family-based immigration. So the first question which we all have is like, because of Trump's rule right now, do we have any impact on family-based immigration?
Good question. And there could be, yes. The short answer is yes. There could be an impact with Trump coming into family-based immigration, and it can happen in many ways. First, and we're saying this based on his first term, what he tried to do, what he did in his first term. Also, we are taking into we're taking into consideration his election promises before he was elected, to understand how he will move forward with family-based immigration. So the first thing to keep in mind is Trump has expressed that he is against family-based immigration. He is against this whole, he thinks of family-based immigration as a chain system whereby, one person comes in, then they invite their relatives to come in, and then the relatives invite their relatives. And so the present Republican administration or to-be administration doesn't believe that family immigration will help the U.S. economy in any way. And they think that by having family-based immigration, it will put a burden on, all the facilities, because then, if somebody becomes an immigrant and if it's not employment-based, because it's not based on having a job, then they will, ask for Medicare, Medicaid, all that kind of thing. So that administration doesn't want it. They are they have an anti-immigration stand right now. So with reference to family immigration, we know that is his stand, that he doesn't believe in family immigration. He wants to replace that with a merit-based, merit-based immigration, which may or may not have any points for the fact that you have a U.S. citizen family member. For example, right now, U.S. citizen spouses, U.S. citizen children, parents, and permanent resident spouses, can file for, and children can file for immigration for their immediate relatives, right? And when it comes to U.S. citizens, there is no cap or no visa number availability issue, because that doesn't come under the cap. And the reason they did this is so that they can keep families together. So it's a humanitarian concern, not just an economic concern, but the way the Trump administration looks at it is that if it doesn't make economic sense, then we don't want, we don't want anyone to come into this country. So that is their stance. And in order to stop family immigration, they can do many things. What they did last time is public charge. So they changed the definition or expanded the definition of public charge, and so much so that more people came under the under who can be considered as a public charge when compared to presently the way it is and how it was even before that. So they can expand the public. What does public charge mean? So in order to get a green card, if it's a family-based green card, especially if you're filing a 485, you have to show that you will not be a public charge or take any public benefits when you're given the green card. So how do they look at this? They look at the past to see if you've taken certain public benefits in the past. That's the present rule. It's very specific. They don't include food stamps. The only two things they include as to with reference to public charge is SSI, that is supplemental income. So if you're getting income from the government because you can't support yourself, that is considered to be then you will be considered to be a public charge and you won't get a green card, or any long-term institutionalization. So if you've been admitted into like a nursing facility, for example, or a mental health facility for a long time at government expense, then you would be considered to be a public charge if you file the green card moving forward. Or even if you, so that those are the only two conditions right now. But when Trump was president, there were many more conditions. Everything was included, welfare, if you took housing, everything. And also, they the officers were allowed to make a determination of whether they thought you are likely to become a public charge based on whether you are employable or not. So, for example, if you file for your aged parents, 65 or above, they're obviously retired. So it's unlikely that they'll be working. So the officer can very well make a determination that, okay, well, we think this person is going to be a public charge because they're not working. Even though they have an affidavit of support from the sponsor, from their child, we still think that, they will be a public charge and they can, basically deny the green card. So that's definitely one way of doing it, through the public charge rule. They can also just remove it, like I said. But for that, I think they obviously need to change the law, and that's not that easy because, they do have the support of both the House and the Senate, right? As for the first 2 years at least. So, but I think it's still more difficult to change the law versus, making it more difficult in these other ways. Another way they can make it difficult is by just increasing the processing time. If they make the processing time like 3 years, then, sorry, I thought I lost you for a minute. If they make the processing time 3 years, then, it's, or 5 years, then it's as good as, not having that benefit, right? Because benefit that is delayed is a benefit that doesn't exist.
Yes.
So these are some ways that they can change the whole family-based immigration scenario. Also, just asking for more documents, conducting interviews, denying cases based on interviews, especially spouse-based cases. They have a lot of discretion, USCIS officers, so they can use that discretion to the detriment of, people who are applying for these visas.
So, Ms. Prashanthi, you are referring to affidavit support while you are explaining the process. So, what exactly is affidavit support and why is it required for a family-based immigration?
So, the affidavit of support is a form that is filled out by the sponsor, where the sponsor is declaring their income, declaring their family size, how many people they are supporting, their immediate family, and showing that they have enough income to support the person they're sponsoring. So there is a certain income requirement depending on the size of the families. So family of 2, family of 4, there's a certain amount of money that you should be making in order to support, be able to file the green card.
Okay.
For example, it's around 35,000 for a family of 2, I think. So I don't remember the exact numbers, but it's over 25,000. And, most people holding a decent job can file a green card for their family. So that's the affidavit of support. So that has to be filled out by the sponsor. And it is an affidavit, meaning they're swearing to support their family member and be responsible for their family member. So that's what an affidavit of support is. And without that, you really cannot file a green card.
Okay. And what would be the chances of denial and what would be the reasons, like common reasons for denial?
Based on affidavit of support?
It can be with affidavit support or common with happened in the last.
Common reasons. Okay. So with reference to affidavit of support, the reason would be that they don't have enough income, right? Or they're not able to produce proof of income. They didn't file a tax return, or the tax returns are not showing sufficient money, etc., etc. That could be a reason for denial based on the affidavit of support. There can be many other reasons for denial of a family-based petition. One is not submitting proper documentation. Like if you don't submit a birth certificate based on, their requirement, then you have to submit secondary evidence. And if you're not submitting secondary evidence that is, the type of secondary evidence that is required. So for example, you have to submit either a birth certificate that was registered at the time of the birth and is given by the proper authorities. So every country, it's a different authority that gives it, but generally it's the Department of State has a list for every country as to which authority gives it. But generally it's the Registry of Birth and Deaths that does this, the health department. Usually it's the government that gives these health birth certificates. So if you get a birth certificate from the consulate, Indian consulate, if you're from India, that is not sufficient proof of birth. So then you have to submit secondary evidence, and you have to submit evidence that if you're born after 1980s, that your birth was never registered, because it became compulsory to register the birth after, 1985, I think, or somewhere in the 1980s. So if you're not able to show non-availability certificate, which is the proof that it was never registered, and additional supporting documents, secondary evidence, such as affidavits from your family members that you were born on that particular date in that particular place, or school leaving certificates for Indian nationals, letter from a priest, a letter from a hospital. These are all acceptable secondary evidence. So if you're not able to submit such documents, then your green card might get denied. So that is for documentary purposes, it could get denied, or it could get denied if you are out of status previously and you're not filing based on US citizen immediate relative category. As you know, immediate relative category, even if you're out of status, as long as you entered with inspection, you're fine. But if you're, for example, a permanent resident filing for your family member, then the family member has to be in status. So if they're out of status or have ever been out of status in the past or worked without authorization, then it's possible that the green card can get denied. The green card can also get denied if you have an interview and you don't pass the interview, and they are not convinced that you're husband and wife, if it is a spouse-based green card, because there's a presumption of fraud in all spouse green cards, and you have to prove that the relationship is bona fide.
So what happens if this kind of denied, if the green card is denied? What happens to the spouse or the relative member?
Well, it depends on what is their status. If they're presently in status, nothing happens. They continue to be in that non-immigrant status. If they're out of status, then they can be put into removal proceedings. And they can be asked to leave the country. Or they will have to leave the country if they don't, so it's important that you leave as soon as you get your decision, whatever it is, right? And most importantly, it could be denied if you have some kind of a criminal case against you. Unless you have some kind of a waiver, then they could deny the case based on that as well, that you have a criminal record, that you've been convicted of a crime. If it's a petty offense or a misdemeanor, there are exceptions to that. There's a petty offense exception. But if you've been convicted of a felony, then you have to file a waiver. So there's a whole procedure. So your case can be denied because of that also. So there are many reasons why your case can get denied.
So we were talking about all these birthrights and all. Once we hear that Trump's administration, we have a new thing called as birthright citizenship getting denied. Is it belonging to the family-based category, or is it separate entirely?
That is separate, because right now there is no immigration process. If you're born in the US, you automatically become a US citizen. So there's no immigration procedure that has to take place. As long as you get a birth certificate from your hospital, then you can apply directly for a passport. That's it. So you're a US citizen by birth. Now, to remove that, again, will take an act of the law and an act of Congress. And Trump cannot do it on his own through an executive order. So I don't think he will get enough votes. He won't from the Democrats and Republicans. Everyone has to vote because it's very close, right? The House and the Senate both, he has a very marginal majority. So everyone the Republicans have to vote for it. So I doubt that will happen. So it's very difficult to get rid of birthright citizenship. So let's see, but it's difficult.
So what is the cost and fees associated with this family-based immigration or visas?
So obviously, I mean, you might have the attorney cost if the attorney is filing, but you also have USCIS filing fee, which I believe is $12.25. And it's 900 and something if you are under 14 years of age. So that's pretty much your cost, the USCIS filing fee, which you have to pay. And that 485 fee is, for each person that you apply for. And there's also a fee associated with the I-130 as well, which is again a few $100s. So, pretty much around 1,500 or about $2,000, $1,500 to $2,000, a little bit more would be your total fee.
So are there any common mistakes that will cause the processing to be delayed?
Yeah, if you don't submit the correct fee, if you don't write the check properly, so many reasons. If you don't sign your application, if you don't miss out checking a box, there's zero tolerance policy. And under Trump, it'll be worse. But if you send it to the wrong address, any of those things, the case comes back. So that's a delay because it doesn't come back immediately. They take a month or sometimes longer to send the case back. So if you are filing and your status is expiring, then you won't be able to refile because by the time it comes back, maybe you won't be in status anymore. Unless, of course, you are an immediate relative, then it doesn't matter. A US citizen, immediate relative, then your status doesn't matter. Otherwise, it does. So any of these reasons, entire case can come back. And if you don't do a proper job, or even sometimes when you do, but the officer doesn't do a proper job, they can send an RFE, a request for further evidence. That delays the process as well, because then you have to respond to it, then they again have to review it. So it does take time when there is an RFE. Usually if you don't submit medicals, I mean, the way of avoiding these kind of delays is submit all the documents that you know will, lead to an RFE. Some things you can't predict, but some things you can. If you don't submit a birth certificate in the proper format or proper secondary evidence, there will be an RFE. If you don't submit medicals, there will be an RFE. So at least submit the documents that are in your control and that you can submit at the first time, rather than you waiting for them to send an RFP. Some people don't like to send their medicals. They say, okay, we'll send it on when we get an RFP because we want to file immediately. But either way, whether you're delaying the initial filing or you're delaying the filing because of an RFP, there's still a delay in filing. So I do believe that especially these documents without which you cannot get an approval, I think it's important that you should submit them initially itself. So you can, if you file those if you submit all those documents, you can avoid, those delays. But sometimes, officers, for example, there was a case where I submitted a birth certificate. They sent an RFE saying that, oh, there's no birth certificate for the child. And then we clearly see in the scanned documents that there is a birth certificate and it meets all the requirements. So sometimes, the officer does not notice because you're sending them 600 pages. If it's a family of 4, there's such a big package that sometimes they don't notice. So that can happen as well.
So who all are eligible for this family-based immigration? Like we know immediate relatives and like who are all eligible for this family-based immigration?
So of course, immediate relatives of US citizens. So immediate relatives of US citizens are parents, children, and spouses. So they don't even require a green card number. So there's no cap for them. So they can file at any time. And they don't have to, there's no waiting period for their green card to become available. So they don't have to go and look at the visa bulletin every time. But the family sponsored preferences which come under the visa bulletin are F1, which is unmarried sons and daughters of US citizens. Then you have spouses and children and unmarried sons and daughters of US citizens. Then you have spouses and children of permanent residents. Then you have unmarried sons and daughters, 21 years and over, of permanent residents. You have married sons and daughters of US citizens and brothers and sisters of US citizens. So basically it's US citizen, children, spouses, parents, and then which doesn't come under any preference category. Then it's US citizen, children over the age of 21, which comes under a preference category. They're not considered to be immediate relatives, or if you're married also, you're not considered to be an immediate relative. So you come under a preference category. And of course, spouses and children and unmarried, children over 21 of permanent residents also come under a different category. And then you have brothers and sisters. So these are basically, parents, brothers and sisters, children of permanent residents and US citizens that you can file the green card for. You can't file for your cousin or for your uncle, so they're not immediate relatives.
So if the siblings are married, can we file for the married
Yes,
siblings?
you can file for married siblings and their family members as well.
Okay, so what is the petition process, like how to file or what are the steps that we need to, to get our spouse or somebody a family-based immigration?
So it depends on where they are. If they are abroad, then you have to file the I-130 petition, wait for it to get approved. Then National Visa Service will contact you. They will then ask you to pay the fee online through the NVC website, through their portal. They'll ask you to fill out the DS-260 forms. It's kind of like a 485 form. They'll ask you to fill out the DS forms. Then they will ask you to upload documents, all your relationship documents like the birth certificate, marriage certificate, proof of marriage, passport, etc., etc. So they'll ask you to upload all those forms, pay the fee, fill out the affidavit of support like we discussed, and all the documents related to the affidavit of support. And once they're convinced that all the documents are there, they send a notification to the consulate. And in India, for example, it's the Mumbai consulate that takes care of family-based petitions. And then the consulate will notify you of an interview date. You go for an interview. Once you take all your originals with you, once approved, they will give you an immigrant visa stamped in your passport. And they'll give you a sealed package. You take that sealed package, come to the US. At the port of entry, they will process it. And, you will get a green card in the mail. That's if you are outside the country. If you're in the country and your priority date is available, so if you're an immediate relative, since there's no priority date requirement, you can file an I-130 and a 485 adjustment of status together with USCIS. And you can also file for an employment authorization document. You can also file for advance parole, which will allow you to travel. You can file all these forms together with USCIS. They will process it, takes about 12 to 18 months. They may or may not be an interview. And they will, send either a request for further evidence, and then they will either approve it or deny it. And depending on the decision, if they approve it, then you will again get a 485 approval, I-130 approval, and then you will get the green card, the actual card in the mail. So that's, a process if your priority date is available. But say your priority date is not available and you're in the country, then you just can only file, whether you're in the country or outside the country, you can only file then an I-130. And then you have to continue to remain in status if you're in the country until that I-130 priority date becomes current. You have to go to the visa bulletin to check that. Go to travel.state.gov. Visa bulletins are published, every month. So you have to look at your visa bulletins, see what your priority date is. Your priority date is always mentioned on your I-130 approval or your I-130 receipt. So there's no suspense as to what your priority date is. Once your priority date becomes available, then as long as you've maintained your status, then you can file for adjustment of status. So that's the process in a nutshell.
Okay. So for H-1B, we generally know like EB1, EB2, EB3 categories, and we have the priority dates. And is it similar to the priority dates for family-based, or is it a little bit different?
It's similar. So there's F1 category, F2 category. So F1 is unmarried sons and daughters of US citizens. F2 is spouses and children and unmarried sons and daughters of permanent residents. F2A, F2B, F3 married sons and daughters. F4 is finally brothers and sisters. So based on the F1, 2, 3, 4, it becomes worse. The wait becomes longer. So the worst wait is for F4, which is brothers and sisters of US citizens. If you look at the visa bulletin, they are working on 2006 priority date.
Okay, 2006.
Yeah. And the best is F1. And as I was saying, F1 is unmarried sons and daughters of US citizens. So the adult sons and daughters of US citizens, they're working on 2015.
Okay.
Which is pretty
If
bad.
21 years old child applies for his parents, what category it would be there?
Oh, so 21-year-old child applies for his parent, then it's immediate relative. Because the child is a US citizen and applying for parents.
Okay, so they get the green card immediately.
I mean, there's a processing time, but there is no wait with reference to visa numbers.
Oh, okay. Thanks, Prashanthi, for all this information. So viewers, if you have more questions and would like to reach out to Prashanthi, you can email at prashanthi@reddyesq.com or call at 212-354-1010 or visit www.reddyesq.com. So this is Priya Goteti signing off, and you can stay tuned for watching more episodes on Sakshi Manasakshi. Thank you.
Thank you, Priya.